Debt negotiation is one of the most direct ways to take control of unmanageable debt. But while the concept seems simple, talking to your creditors to work out a better deal, the process can be legally complex and vary from state to state. In this training, we'll explain how debt negotiation works, who can use it, what the risks are, and how to do it legally and safely. What is debt negotiation? Debt negotiation means working directly with your creditors to change the terms of your debt. The goal may be to lower the total balance owed, reduce the interest rate, extend the repayment period, or create a more affordable monthly payment. This process can be done by the borrower themselves, through a licensed attorney, or with the help of a debt negotiation company. It's different from debt settlement, which typically involves paying a reduced lump sum to resolve the debt entirely. Debt negotiation focuses on adjusting terms rather than erasing the debt. Who can use debt negotiation? Debt negotiation is typically a good option for individuals who are struggling to make payments but want to stay current. Those who want to avoid default or bankruptcy. People with unsecured debt, such as credit card balances or medical bills. Borrowers who are motivated to take an active role in their repayment. It may not be ideal for borrowers who are deeply behind on payments or who are facing legal action from creditors. In those cases, settlement or bankruptcy may be more appropriate. How it works. Debt negotiation can take several forms. Self-managed. You contact your creditors directly and propose a new payment plan or reduced terms. Attorney-assisted. A licensed lawyer negotiates on your behalf and may offer legal protections. Third-party company. A debt negotiation firm handles communication and proposals for you, usually for a fee. If the creditor agrees, new terms are put in writing and take effect, often helping the borrower avoid default, collections, or further penalties. State-specific disclaimer. Important. The legal rules around debt negotiation vary by state. In some states, only licensed attorneys are allowed to negotiate debt on behalf of consumers. Other states require companies to be licensed and impose restrictions on what fees can be charged. Misrepresentation, unlicensed practice, or violating fee caps can lead to legal consequences for both the company and the consumer. Before working with any professional negotiator, always verify that they are legally authorized to operate in your state. Credit impact and trade-offs. Debt negotiation may have less credit damage than settlement or bankruptcy, especially if you continue making payments under new terms. However, if the creditor marks the account as modified or settled, it could still impact your credit score. There is also the risk that a creditor may refuse to negotiate or resume collections if an agreement isn't reached. Some debt relief strategies, especially debt settlement, may result in forgiven debt being treated as taxable income by the IRS. If $600 or more is forgiven, you may receive a 1099-C form, and taxes could apply. Exceptions exist if you were insolvent at the time. Always speak with a tax advisor if you're unsure. Costs and fees. The cost of debt negotiation varies depending on who manages the process. Self-managed, free, though it requires time, effort, and negotiation skills. Attorneys may charge hourly or flat fees, but offer legal protections. Debt negotiation companies typically charge a fee based on the amount of debt or savings, though federal law prohibits upfront fees for services offered over the phone. Be cautious of any company that asks for payment before providing results. This is a red flag and likely violates FTC rules. Risks and red flags. While debt negotiation can be a powerful tool, there are some risks to watch out for. Unlicensed firms operating illegally in your state. Promises of guaranteed results or fast debt elimination. Fees that aren't clearly disclosed. No written agreement from your creditor after a deal is reached. Remember, if it's not in writing, it doesn't exist. Always insist on a signed agreement with new terms before stopping or changing your payments. Tax implications. If a portion of your debt is forgiven through negotiation, especially if your balance is reduced, you may receive a 1099-C form and could owe taxes on the forgiven amount. However, if you were insolvent at the time, you may be eligible for an exemption. Always consult with a tax professional to understand how negotiated debt may affect your tax return. Which debts qualify for negotiation? Debt negotiation typically applies to unsecured debts like credit cards, medical bills, personal loans, collections accounts. It usually does not work for federal student loans unless you're in default and working directly with the government. Secured loans like mortgages and auto loans. IRS tax debt, which requires its own legal process. Debt negotiation allows you to work with creditors to make your debt more manageable by adjusting interest rates, lowering monthly payments, or even reducing the total balance. It's flexible, cost-effective when done carefully, and may preserve your credit better than other strategies. But the process must be handled legally with clear agreements and licensed professionals if you're not doing it yourself. Before beginning any debt negotiation, review your state's laws to confirm legal requirements. Work only with licensed attorneys or registered companies. Get all changes to your debt terms in writing. Understand the costs, credit impact, and tax consequences. Consider professional advice before starting. Need help negotiating with creditors? We can connect you with licensed, verified professionals who understand the rules in your state.